Respected and talented viewers, I'm excited today to have a very nice video on forgery, falsification of accounts, admitted signatures versus disputed signatures, and entries in books of accounts for falsification of accounts. Now, if you are new to our video, then please share it, like it, and subscribe it. If you are a regular viewer, then you have to simply like it and share it. Now, I'll start with forgery. Please remember IP section 463 defines forgery simply seated, whereas sections 465 to 471 describes an aggravated form of forgery. A document can be said to be falsely made if the signature, seal, or date is false. In other words, the signature in case of forgery of signatures must be affixed by a person other than a person whose signature it purports to be, and it must be shown that it was the accused who has affixed the false signature or thumb impression before he can be convicted of an offense of forgery. A false document will not amount to forgery unless there is an element of fraud. The meaning of false document does not amount to a forgery because one of the intents contemplated in section 463 Indian Penal Code is that the false document must be made with an intent to commit fraud, or that fraud may be committed. Evidence of handwriting expert is necessary to prove charge of forgery against the accused. In case of forgery, the evidence of handwriting expert would get weight only if attended to by other circumstances because the science of comparison is not perfect. Now there is a new provision in Criminal Procedure Code under section 311A of Criminal Procedure Code. The magistrate is empowered to order to give handwriting or signatures of the accused. He can order the accused or any witness to bring the offences within the four corners of the section 464 of Indian Penal Code. The false document must be created with a view to make it appear that it was made by some other person who the accused knows did not make it. An incorporation or inclusion of a false statement in a document would not ipso facto make the document false. For a document to be false, it has to tell a lie about itself. When the charge of forgery has failed, the charge of use of false document as genuine will also not survive. That is, IPC section 471 will not survive, means accused will get acquitted. But a document cannot be said to be a false document within the meaning of section 464 of IPC. There can be no prosecution under section 467 of Indian Penal Code. The burden is on the prosecution to prove the ingredient of offense. The onus of proof of the existence of every ingredient of charge always rests on the prosecution, and it never shifts. An accused cannot be convicted only on the basis of fully statement made before the court by him. It is for the prosecution to prove the offense against the accused. Now, admitted signature versus disputed signatures. There is a citation, C. Hemchand and others versus C. Dharam Prasad and others. Year 2000, NOC 115, Himachal Pradesh, para number 9, page number 5. As to admitted signature, by now it is well settled that for a carrying out comparison of disputed signature, there has to be admitter's signature first on the record of the court. Under Section 7.3 of Evidence Act, court of its own can compare signatures, handwriting, and can form its own opinion. Whereas under Section 45 and 47 of the Indian Evidence Act, court can take the opinion of an handwriting expert. Irrespective opinion of handwriting expert, court can also compare admitter's signatures with the disputed one and arrive at an independent conclusion. Section 7.3 of Evidence Act authorizes a court to compare disputed signatures with the admitter's signatures and arrive at its own conclusion regarding genuineness of handwriting signatures. It can be done in 6 ways: by means of direct evidence, by means of familiar evidence, by means of comparison by the court, by admission of the parties, by means of scientific means of comparison by an expert, and by means of circumstantial evidence. By now it is well settled that one disputed document cannot be used for comparison of signatures with another disputed documents, with another disputed signatures. Rather, comparison of disputed signatures would be only useful when it is done with admitter's signature. It means admitter's signature is very important. Now, falsification of accounts. Dealing with Section 34 of Indian Evidence Act. Now, this offence means IPC 477A is non-cognizable, bailable, triable by the first class magistrate. Entries in books of accounts, including those maintained in an electronic form, when it is relevant. Entries in books of accounts, including those maintained in an electronic form, regularly kept in the course of business, are relevant whenever they refer to a matter into which the court has to inquire, but such statements shall not alone be sufficient evidence to charge any person with liability. Simply entries will not help. Now I am giving you one illustration in this respect. A shows B for rupees 1000 and shows entries in his books of accounts showing B to be indebted to him to this amount. This is the situation. The entries are relevant but are not sufficient without other evidence to prove the debt. A man ought not to be allowed to make evidence for himself by writing things behind the back of others. That such entries, though admissible, are not alone sufficient to charge a person with liability unless there is some other independent evidence of transaction. Some more definite and unimpeachable evidence is required. Whether the defendant takes objection or not, the plaintiff, relying on account books, must prove 1. That the books of accounts are kept in regular course of business. The particular entries there must give some corroborative evidence. It is sought to use the entries as substantive evidence under Section 32 of Evidence Act. Sufficient evidence should be given. For these arguments I rely on the following citation. 1994 in bracket 1 CCR 179, State of Gujarat versus Kemchand Shah. Now in this citation, for IP section 477A, ingredients are given when this offence can be proved. Para number 22, page number 8 and 9. It may be mentioned at this stage that the entries in books of accounts or the evidence of books of accounts, ipso facto, without any corroborative evidence, would not be sufficient to prove the guilt of the accused. Entries in books of accounts are supportive and corroborative evidence. This is the value of entries. Entries can never be considered as substantive evidence. And accused cannot be charged just on the basis of entries in books of accounts. When entries from the books of accounts relied upon the prosecution are not sufficient to charge a person with liability even under the provision of Section 34 of the Evidence Act. No person can be stated a charge with the liability merely on the basis of entries in books of accounts, when such books of accounts regularly kept in the course of business. The prosecution is bound to establish the entrustment, criminal breach of trust, and falsification of accounts. These three things are to be proved by substantive evidence before the court. Obviously, therefore, the prosecution is not in a position to make any slice of profit out of documentary evidence relative to cash memos. Prosecution will come out with number of evidence, but it has got no value. For example, cash memos, receipts, and counterfoils of checks and slip books produced and relied upon to prove guilt of the accused. So these evidence will not help the prosecution. Therefore, the evidence of handwriting expert and the audit report also does not prove the guilt of the accused beyond reasonable doubt. Now, some legal analysis. Falsification of accounts affected on a particular date, unless it is part of another transaction, is undoubtedly a distinct offense, and there is a separate charge should have been framed in respect of the same. This distinct offense could not be clubbed together with other evidences. Each defalcation is a separate offense. What does it mean? Suppose defalcation has taken place in the year 2001, 2002, 2003, 4, 5, 6, 7, 8, 9. Each offense is distinct offense, hence it cannot be clubbed together. There has to be a separate charge, and separate charge is to be submitted. Where a charge of criminal breach of trust is not proved, I repeat, where a charge of criminal breach of trust is not proved, conviction under Section 477A, that is falsification of accounts, cannot be sustained. Accused walks away with acquittal. The benefit of Section 212 of CRPC is only available when the accused is charged with criminal breach of trust or dishonest misappropriation of money, and that provision cannot be availed of in framing a charge under Section 477 AIPC, because both the offences are not the same offences. Further, the charge does not mention the particulars as to date of offence, time of offence, and amount. Then it is called a walk charge. So no conviction can take place on such a walk charge. Now these are the important points which I discussed before you. Hope you enjoyed this video, and I really express my thanks from the bottom of my heart for your patience hearing. See you in the next video. Thank you.